Today we're going to be talking about the new South Carolina Property Condition Disclosure Statement that comes out June 1st of 2023. If you haven't subscribe today, hit that button. We have over 160 videos for you for free with the latest information on the real estate market. Hi, I'm Jennifer Nicely with Pinnacle Real Estate Academy. I am your go-to when it comes to real estate and real estate education. Today, we're talking about the new property disclosure form that is coming out June 1st, 2023. Now, this document, they have made numerous changes to, and every single one of them are fantastic. So I know that this is going to be great for your business, whether you're on the buy side or the sell side. Now, this document is now 7 pages. It's no longer 6. So the first 6 pages are your regular property disclosure statement. The 7th page is your additional document for HOAs. So total, we now have 7 pages. Now, on the first page, one of the things that we have added to this is explanation of no representation. As you can see here, it says, by answering no representation on this disclosure statement, the owner is acknowledging that they do not have the current knowledge necessary to answer the questions with either yes or no response. Owner still has a duty to disclose information that is known at the time of the disclosure statement. No representation should not be selected if the owner simply wishes to not disclose information or answer the question. Selecting no representation does not waive liability if owner is aware or subsequently becomes aware. This has been a big problem in South Carolina. A lot of people use the no representation column as a means to plead fifth, as a means to just sweep it under the rug and go, there's a lot going on, but I'm not going to tell what's going on. I'm just going to sell it as is. So if you ever heard someone say that, I'm just going to sell it as is, and they mark no representation all the way down. That is against the guidelines of this document. That's against the law. By law, you have to disclose what you know. No representation means I don't have a clue. It does not mean you get to plead fifth. Now, a couple other things they've added to this document is about floods. One of the major additions they've added is flood coverage. So the old disclosure had always asked, have you had any floods or claims? Well, now they've gone into a little more detail. So as you can see here, there's multiple questions on this. So on question 24, it says whether the property is currently insured through public or private insurance. So that's talking about FEMA or any private insurances. Question 25, private or public flood insurance. Have you had any claims on your property during your ownership with private or public insurance? 26 says, repairs made to the property as a result of flood events were not filed with private or public insurance during your ownership. So now they're covering, has there been a flood where you have filed against your insurance? And then there's another question that says, have you had issues where you had repairs done where you did not file a claim against insurance? Some people have been hiding under that. There was a flood, they didn't file a claim, and so they go, nope, nothing's happened, and they sweep it under the rug. That is no longer the case because there's a direct answer and question. Now, take a look at this form again. Number 27. Has federal flood disaster assistance been previously received during your ownership? So, have you gotten any assistance from FEMA, Small Business Administration, HUD? Has anyone helped you outside of insurance? So then again, we are covering all bases when it comes to floods, whether you made claims or not, whether you got assistance or not, there are check boxes there. Now, question 28, back to the form. Whether the property has been assessed for a beach nourishment project during your ownership. Now, keep in mind with beach nourishment, you may have an assessment. You may not have an assessment. It depends on if it's privately owned land, if it's publicly owned land, if the federal government's stepping in, if the state is assisting with the federal government. So this question covers a lot of bases. It does not necessarily mean that you paid for the beach nourishment, but keep in mind on those private areas of land, they are responsible for their beach renourishment. The federal government is not stepping in on that. Now let's go back to the form and look at additional additions to this form. Let's go back up to 22. Erosion control structure such as bulkhead, rock, revetment, seawall, or buried sandbags affecting the property. This has been an issue down in Dubuardo. We call it Debbie Do. This has been an issue down there with sandbags and the government wanting to step in and do away with them because it's not a loud revetment or a loud seawall. It's just temporarily what the homeowners have put in place. This is why 22 is in there. Back to the form, let's look down on A and B at the bottom of 28. It says, describe any green energy, recycling, sustainability, or disability features for the property, and describe any Department of Motor Vehicles titled manufactured housing on the property. Both of these are major concerns we've had in the past. So let's say you have a mobile home, and the mobile home does not have a title. Maybe it has a title with the DMV as in a vehicle, but it does not have a deed and a title as in real estate. And you don't find this out until pending status, until you're under contract. That can definitely be a problem. This is why it is here on our property condition disclosure statement. Now, the last addition they've made to this, if you will look on page 6, here we show you they have multiple check boxes. All of these check boxes have remained the same except the one that says subject to vacation short-term rental. This is a really big deal. We have something in South Carolina called the Vacation Rental Act. And what that means is the state of South Carolina wants to protect our tourism industry. That's the biggest part of one of our revenues for our economy. And so we want to protect that. So what happens is when a homeowner rents out their property and then they go and sell it, the state law says that the new homeowner has to honor the next 90 days worth of rentals. Well, sometimes sellers will sweep it under the rug and not tell anyone, or not tell them until after they're under contract, and then the buyer's locked in and has to honor those next 90 days. Or the buyer is tempted to not follow the law, which is illegal and they shouldn't be doing. So the fact that we've added this to our property condition disclosure statement is fantastic. So although our document is now 7 pages instead of 6, it is in your best interest. It's in the seller's best interest and the buyer's best interest. So this is fantastic. All of these forms should be in your zip forms, your dot loop, or whatever program you're going to use on June 1st of 2023. If you have any questions, as always, please comment below, reach out to us. We're always here at Pinnacle Real Estate Academy to help.